Good morning, everyone. This is, I believe the final commercial webinar before the summer break, and I'm delighted to be presenting it with my first pupil, Tina Ranales-Cotos, and we're going to be addressing this morning the issue of protecting confidential information in injunction proceedings. We have some slides. There's also a handout which can be made available from Chambers after the webinar has finished. The principle which governs really and is the foundation of our talk this morning is the principle of open justice, and that's a fundamental principle. Those of you who've ever been at the Civil Justice Centre and seen the designated civil judges on a Judge Bird go round and turn signs from saying private hearing to public hearing, it's a real fundamental principle. The public simply has an interest in knowing and a right to know who comes before the courts and what they're arguing about. To this end, the general principles are that copies of statements of case can be obtained by any person from the court file. That's CPR 5.4c. Court lists are published with the names of the parties. Hearings are held in public, and judgments or orders made at such hearings are available to the public. The application of these principles is obviously restricted by the rules of court in relation to specific types of proceedings. For example, child and care proceedings in the family division. In all other cases, these principles will apply unless a party can persuade the court that some or all of them should be disapplied in a particular case. And the starting point is it will only be in exceptional cases that the principles are disapplied. When you're considering applying for injunctive relief to restrain the misuse of confidential information, you are going to need to consider at the outset as to whether or not the hearing can proceed without referring and deploying the confidential information. As you'll be aware, if confidential information is referred to in a public court hearing, then confidentiality will have been lost, the obligations of confidentiality rendered nugatory, and the application for relief would be self-defeating. If it is not possible to make an application without referring to the confidential information, then application for the hearing to be held in private will be necessary. Now, if we just pause there and consider some examples, often you're dealing with a case where the confidential information is said to be a customer list. It isn't usually possible to carry out that hearing without actually putting in evidence the detail of the customer list. It's the fact of the customer list which has been removed. So in that case, you would say that the hearing could proceed without referring to the confidential information. We give there the case of AAA and CCC in the Court of Appeal in 2020. That was an appeal from a decision of His Honour Judge Eyre made in private, anonymised proceedings for summary judgment, and there was an appeal against his decision. The Court of Appeal took the view in that case, in conjunction with the parties, that it wasn't the hearing in the Court of Appeal did not need to take place in private, as the hearing could proceed without referring to the confidential information which underlay the proceedings, and there could be the added protection of if there were any slips in that matter, the transcript could be reviewed after the hearing. So the first question is always going to be, can the hearing proceed without referring to the confidential information? If not, then you really have to consider what do you need to do to protect the information from being disclosed in public. And you're going to look at this, first of all, is what documents or materials are going to be referring to the confidential information. Relevant will be a consideration of statements of case, skeleton arguments, judgments, and orders which will necessarily refer to the confidential information, and the papers for the hearing at which the confidential information is referred to. When you're applying for such an application, you're also going to have to give thought as to how the confidential information in the application is going to be referred to in the supporting evidence. Obviously, that won't be a particular issue if you're making the application without notice and can seek the appropriate protections subject to review on the return date. The important thing to bear in mind is, all because you obtain the necessary protection orders at the outset, these don't apply necessarily for the whole of the proceedings. They need to be kept under review throughout the whole proceedings, and in particular at any return date. Equally, if you have an order at the outset for example, protecting papers on an injunction, but then you're going to apply for summary judgment. Then before applying for that summary judgment, you may want to seek an application to protect the papers which are going to be created for the summary judgment application before making that application for summary judgment. So there's no slippage in the protection of the court papers and the confidentiality. One thing to be very alive to is sometimes practitioners will think, well, it doesn't matter. The hearing's in private. That ought to be sufficient to protect what is happening in this case. But you've got to be aware of what is referred to as jigsaw identification. And the Dedadone and BBC case, which we give on the slide, gives a very neat definition of what jigsaw identification is. If I give you an example, if, for instance, scurrilous allegations are being made on the internet or in the press, they don't name the individuals, but suddenly they pick up from the court list that an injunction application has taken place between two parties who fit the profile of the allegations which have been made, then there's a risk of jigsaw identification. In such circumstances, in addition to asking for the hearing to be in private, you're going to be asking for the parties to be anonymised. There's also, in addition to jigsaw identification, there are two recent cases which Tina will consider at the end of this talk. There are other situations where an anonymity might be required. For instance, you don't want it becoming known that you've, for instance, have been subject to an attack or something by hackers, and you think it could damage your business, in which case you may want to have anonymity. But Tina will deal with those cases after I finish with the outline. In this case, we're very lucky in that what we have to do in such cases is all very helpfully set out for us in the practice guidance on interim non-disclosure orders. And that is the essential reading. In effect, any application a court will expect to be taken to this guidance, and insofar as there's any deviation from the guidance, the court will expect that to be drawn to its attention and an explanation given as to why it's been deviated from. The guidance sets out recommended practice regarding any application for interim injunctive relief in civil proceedings to restrain the publication of information, and that deals with engaging with protected rights under the European Convention of Human Rights, and also importantly guidance concerning the proper approach to open justice in respect of such applications. Other guidance which you should be looking at in this regard is the H and Newspapers Group, give the paragraph there, anonymity. 39.2 of the CPR, which deals with private hearings and anonymity, and very good guidance in the SOJ-JOA case in 2019. The guidance structure, just to give you an overview, is it firstly very helpfully gives you the model order. And again, like a freezing injunction or search and seize order, this is the model order which the court will expect to see before it. And again, any deviations from the same identified and an explanation given in submissions and skeleton argument as to why you have deviated from the model order. We'll come to that in a moment. Paragraph 9 deals with the thing we've already set out, the open justice fundamental principle. The general rule is that hearings are carried out in and judgments and orders are public. Paragraph 10, derogations from the general principle can only be justified in exceptional circumstances when they are strictly necessary as measures to secure the proper administration of justice, again stressing they are wholly exceptional. 11, the grant of derogation is not an exercise of discretion. If you, for example, satisfy the requirements in CPR 39.2 for a private hearing, then the court does not have a discretion as to whether or not you have a private hearing. It's obliged to give you that hearing in private. 12 is an interesting one. They say there is no general exception to the rule of open justice where privacy or confidentiality is an issue. That's paragraph 12. However, the Armstrong-Watson case, which Tina refers to, in that case, the High Court proceeded on the basis that really the accepted practice is that where you have confidential sensitive information, which has to be referred to and deployed in the hearing, then a hearing will be in private. I think really what paragraph 12 of the guidance is referring to there is you shouldn't automatically think you get it just because you come along with confidential information. You've really got to apply your mind as to whether or not you need to refer to the confidential information, or you can protect the confidential information in a way other than the draconian step of having a hearing in private. Paragraph 13 is clear. The burden is on the applicant really to demonstrate why any derogation from open justice, and it must be set out with clear and cogent evidence. Just to give you some other things you can look at, insofar as third parties going to be impacted by your order, that's provided for in paragraphs 24 and 28, and also in the model order. Now, the model order, I think it's no better. This shows you the type of provisions you could be looking for. And we've put on the screen there, typical, the model order provision for anonymity. And you see there, and you see paragraph 3, it sets out the judge has got to be satisfied it's strictly necessary. The claimant is permitted to issue the proceedings, naming the claimant as AAA. And then the claimant permitted to issue these proceedings, naming, and it provides for what the first defendant's to be named as. And that is an anonymity order, subject, unlike order for privacy, will usually carry out through the case, provided it's the court is satisfied at the inter partes hearing that anonymity was properly granted. The next part of the model order is paragraph 4, and that's dealing with the access to documents. And really, this is critical for your consideration of whether or not you need this protection, because you're going to look at what the documents you're going to be creating the case and to what extent you want to keep them from public view. Statements of case, copies of witness statements, applications will not be provided to a third party without order of the court. Any non-party other than the person notified of the order seeking it must make an application to the court to get access to these documents. We then have the injunction, and the injunction provision means not just the confidential information which is going to be covered in the proceedings, but it's also going to involve protection of the case papers. Also, if you see it little b, publishing any information which might identify the parties to the litigation. That's at little b of paragraph 6. And then we have paragraphs 10 through to 12, the protection of the hearing papers. And again, this is going to be your consideration as to what hearing papers you believe need to be protected. And you see, it's a very wide-ranging provision. The only thing I'd just draw your attention to here, surprisingly, it doesn't include skeleton arguments, but in cases I've done, we've always altered and asked for permission to alter the standard wording to make sure skeleton arguments are covered as well, as it's likely that skeleton arguments will be referring to whether or not the detail, but certainly the nature of the confidential information. So protection is needed in that regard. Anonymity is dealt with at HN News Group newspapers I gave you the reference to earlier. And just I've brought out the key parts of that paragraph. You'll see there the general rule is that names of the parties are included in orders and judgments. There is no general exception for cases where private matters are an issue. So just because you're discussing private finance issues or private dealings between parties, that doesn't justify anonymity. An order for anonymity or any other order restraining the publication of the normally reportable details of a case is a derogation principle of open justice. Accordingly, where the court is asked to make such an order, it should only do so after closely scrutinising the application and considering whether a degree of restraint on publication is necessary, and if it is, whether there is any less restrictive or more acceptable alternative than that which is sought. So on any application, you're going to have to demonstrate to the court that you have considered whether or not there are any lesser alternatives, explaining what they could be and why you don't believe they're suitable, just so the court sees that you've engaged with that approach. And then again, an anonymity order or any other order restraining publication made by a judge at interlocutory stage of an injunction application does not last for the duration of the proceedings, but must be reviewed at the return date. And that's back to the point there. You usually get the anonymity order without notice application, but it must be reviewed at the return date. So again, you're going to, because you've got it at the ex parte stage, doesn't mean you don't have to be engaging with the issue before the judge on the return date. This is very much a whistle-stop tour, so apologies for the speed which I'm having to go at here, but I hope this will give you the flavour, and especially when the handout and the slides will be available. 39.2 is the provision you're going to consider when considering whether or not to apply for a hearing to be in private. And again, it sets out the general rule there. And then at 3, a hearing, any part of it, can be in private, and it gives certain cases where that would be the case. And the ones you're going to be considering in a confidentiality information injunction type of case is A, publicity would defeat the object of the hearing. So, for instance, if you're trying to prevent your former business partner from disclosing dealings between you in the business sector, and you don't want them becoming public, but you have to refer to them in the injunction, then obviously that's going to defeat the whole object of the hearing and the application that you're seeking. Little c involves confidential information, including information relating to personal financial matters, and publicity would damage that confidentiality. Again, you don't want information to get out to your competitors. You're seeking to protect it being misused. It's private matters. Again, that you'll be engaging with that hearing. E is one which often gets overlooked, especially on without notice applications, and it's considering the position of the respondent. It's a hearing of an application made without notice, and it would be unjust to any respondent for there to be a public hearing. For instance, there might be cases where you're making very serious allegations against the respondent of the type which could damage their reputation or their character. And you may want to give your mind as to whether or not it's fair on a without notice application that those are in effect advocated in public, as opposed to being dealt with in private on the without notice application, and then that being reconsidered on the return date when the respondent has the chance to defend themselves and see whether or not they wished for it to be argued in public. And again, G, the sweep-up application, the court for any other reasons considers this to be necessary to secure the proper administration of justice. Back to the point I made earlier, bearing in mind that the court has an obligation, if any of these grounds are satisfied, to direct that the hearing is in private, there's no discretion, your submissions must be referenced and anchored to this CPR 39.2 and the particular grounds that you rely upon, and also your evidence in support of the application should address the grounds. Again, finally, at subparagraph 4, the court must order that the identity of any person should not be disclosed if and only if it considers non-disclosure necessary to secure the proper administration of justice and in order to protect the interests of any person. So that's the subparagraph that you're going to address in any anonymity application. You're going to say why it's necessary to secure the proper administration of justice or to protect the interests of any person. Finally, from my point of view, a breach of anonymity privacy restrictions is viewed very seriously by the courts and is likely to be conduct that crosses the custody threshold on a committal application, AAA and CCC. The Court of Appeal, in that case, the judge at first instance refused to make it an immediate custodial sentence in circumstances where the respondent had gone out straight after injunctions and disclosed the identities of the people who were the parties to the injunction. He'd also disclosed the information he'd been told not to disclose. The Court of Appeal said the judge was completely wrong on that. It was probably the very egregious breaches, and therefore they remitted it back to the judge to reconsider, and an immediate custodial sentence was made. So if you are dealing in this situation, and especially if you're acting with respondents in those cases and you receive such an order, you want to make sure you have chapter and verse on paper to your client, setting out what they can and cannot do and the consequences if they breach that. Again, apologies for a very whistle-stop tour through the relevant structure and the relevant principles that you need to consider. I'm now going to hand over to Tina, who will deal with some recent cases that we've already just touched upon. Thank you.
Thank you, Mark. Good morning, everybody. So I propose to spend around 10 minutes just cantering through the clutch of cases that They are identified at the bottom of the handout, and they're all very recent and they're all High Court cases. So I'm just going to hopefully go through those cases to underline really the principles that Mark has set out very clearly in the slides on the screen, and hopefully just to pique your interest and give a flavour of how those principles are then put into practice and how they've been deployed. So the first case, so I'm going to deal with them in chronological order. So the first case, and these are all on the handout at the very end, is EGC and PGF. As with all of these cases, by their very nature, because of the applications made, the names are often anonymised or ciphers are used. I think that case is useful principally because it really does give you an overview of the landscape. So to put into context, essentially, the principles that Mark has set out, and bearing in mind that this talk is really all about the principle of open justice, that case I found to be particularly useful. It's quite a short case, and it gives you the landscape, as it were, in terms of what does open justice actually mean. And Mark's obviously touched on this, but the judgment, the open judgment, goes through in a helpful way, I believe, the various tenets of open justice. So those are the need for a hearing to be in public, the need for the parties to be identified by name and address, the absence of any reporting restrictions, and the ability to access court documents and inspect the court file. So anything that touches on limitations in relation to those four matters essentially are derogations to that fundamental principle of open justice. And that authority does set out the basis for all of those gateways, as it were, tenets of open justice. And then it sets out, if you're to make an application, which would amount to a derogation in relation to any of those areas, the basis for that application. So it's a really good route map, in my view. And of course, the first thing it refers to is the guidance, which Mark has helpfully gone through, and in connection with whether or not a hearing should take place in public or exceptionally in private, it refers then to the relevant rule, Rule 39.2, and then the various gateways that Mark's touched on in relation to whether or not you can make out a case for a derogation in relation to a hearing that would ordinarily be in public. It then deals with anonymisation, which is dealt with again under Rule 39.2, and that's sub-Rule 4, which sets out the test of necessity and securing the administration of justice. In relation to reporting restrictions, helpfully it makes the point that the juridical basis for that would be Section 11 of the Contempt of Court Act 1989, but it makes the point, which sometimes is easily lost, that is simply an ancillary statutory power. So there already has to be a decision made that there will be anonymity or that there will be a hearing in private, but that's an ancillary basis for imposing further restrictions, which may be useful, for example, reporting restrictions. And then it goes on to deal with the access to the court file and the basis for restricting access, which is built into the Rule 5.4c. So I think if you're in any way dealing with a case where you think there is, for example, and this talk is obviously focusing on misuse of confidential information, then it's a good starting point to remind yourself about the principles that Mark has clearly set out in his handout. That was the facts of that case were quite unusual because it was an application by the claimant who was a doctor employed by an NHS trust, and in fact the NHS trust itself was neutral on the application. And that really underlines the point that it's not a matter for the parties to consent. The application has to be made, there has to be cogent and clear evidence, and the application will be scrutinised. So it's worth remembering that even if the other side are neutral, it doesn't in any way reduce or curtail your obligations as the applicant in relation to the burden that you have to satisfy. On the facts there, the application was refused, ironically, because the application that was made for anonymity, it transpired the paradox there was that it wouldn't actually achieve its objective, and it was to do with the fact that the case had been widely reported in the media previously. So even if anonymity had been granted, it was likely that it wouldn't achieve the objective because basically the jigsaw identification point. And then in terms of the objective of protecting the confidential information, anonymity wouldn't do that either. So I suppose that case is, in summary, be careful what you wish for and make sure that when you're applying that you fashion and you seriously consider whether you need it and to what extent do you need it, and what would you need in order to achieve your objective. So that's EGC. The second case that I wanted to touch on, not in any real detail, but it's the XXX case and persons unknown that Mark referred to during his slides. And that again was an application for anonymity. The facts there are again quite unusual because the claimant who was applying was a company who was providing technology-led solutions in the context of very sensitive information and highly classified information involving projects of national security. So a very specific arena. And there, in fact, what was being claimed, there'd been a without notice application, there'd been an on notice continuation hearing, and it was an application for a permanent injunction by way of summary judgment. The defendants, who were persons unknown, hadn't in fact engaged at all throughout the entire process. But even so, again, it shows you that even where you've got, by definition, persons unknown that are not engaging and they can continue to not engage, then you still have the burden to discharge, and it is an onerous one. There, the three issues the court had to deal with included whether or not to continue the anonymity order, which had been granted. As Mark said, that is an order that has to be continuously reviewed, particularly if it's obtained without notice. And then second, whether or not the hearing should take place in private. And third, the actual summary judgment application. And in relation to anonymity, the court went through the guidance and the rules, which I've already referred you to in EGC, and it dealt with the derogations and in particular, potentially useful if you're looking at a case involving confidential information. One of the bases to apply a derogation would be the maintenance of administration of justice. And there the court made clear that breach of confidence or confidential information cases where the very nature of the application is made because the information could well be destroyed, and then any relief rendered nugatory, was a paradigm example of a case that fits that particular derogation. There's also the other common basis for proceeding for a derogation of the open justice principle would be harm to legitimate interests. So that would be interference with convention rights. And again, if you think that those are in play, then you would consider whether to make an application, whether it's for anonymity or for a private hearing, reporting restrictions and limiting access to the court file. And again, that is a paradigm example of where the court will consider such an application where there is the possibility of interference with convention rights, and the court then has to carry out the usual balancing act and the need for clear and cogent evidence in relation to that. So those two cases are a useful starting point. The more recent cases, and particularly the Armstrong case that Mark has mentioned, where it starts to get perhaps more interesting in the context of the sort of case that you might deal with in your practice. So there, the claimant was actually an LLP involved in accountancy and tax and business advice services. And there they were the subject of a hacking intervention by persons unknown. Their IT system was hacked and confidential information was stolen, including commercially sensitive information, not only relating to the company, but also its staff, its business and its customers. And then the hackers subsequently contacted the claimant effectively to blackmail them, interestingly, for payment in Bitcoin. But there we are, with the threat that the information will be released to the public at large, or more likely in the kind of hacking kind of cases on the dark web. So a paradigm example of an application that was made both without notice and for various interventions by the court that would seriously impact the principle of open justice. And that's an interesting case because it shows you how those principles that we've referred to were applied by the High Court. And the underlying causes of action against the persons unknown, of course, was breach of confidence and confidential information in the context of blackmail. I think it's a useful case as well in relation to the sort of evidence that you need and the fact that you need to obviously refer to and turn your mind to the various tests, not only in relation to confidentiality, but also in relation to going without notice, the need to show a good reason. And to some extent, that if effectively allies with the need to show a derogation in relation to a hearing in private. So Mark touched on those gateways that are set out in the rules, Rule 39.2, sub Rule 3, A to G. And there they relied on three, in fact, specific gateways involving the fact that the hearing in public would defeat the object, given that the subject matter was confidential information and blackmail. And also there was confidential information itself that could be damaged if the hearing was not in private, and therefore the very need for the relief would be rendered futile, and also just securing the proper administration of justice. So three gateways there in play. The guidance was also relied on in that respect, and the need to address that in the evidence. And as Mark said, Armstrong really makes the point that if you're dealing with a case involving confidential information, then a private hearing would ordinarily be the solution, although that means that you do still have to address the necessity for it and whether there are any other types of processes that the court might fashion to address the issue. And just on that, the court did consider the prospect of the expedient of use of confidential schedules. Obviously, that's something that could potentially address the issue, but ordinarily, where there's a need to address the information beyond the nature of it, then the schedules wouldn't suffice, and there'd be a need to refer to ongoing investigations, for example, in the Watson case, because they were still trying to identify the blackmailers themselves. And the ongoing investigation, disclosing that in an open hearing would have compromised the investigation. The court also considered there was a mandatory injunction being sought in terms of delivery up of the information. Of course, the test there is a higher one. And the court also considered whether or not freedom of expression, so convention rights, were engaged. Section 12, subsection 3. Interestingly, the court found there that because of the blackmail, there was no legitimate interest being or that could possibly be put forward by the blackmailers had they attended. So the court found that the convention rights weren't even engaged on the facts of that case. But Armstrong is an interesting case, and it's a good case to have a look at if you're considering an application where the persons unknown may not be within the jurisdiction, which is often the case. I mean, on the facts of Armstrong there, I think that was the case where the blackmailers, I think, had used potentially addresses emanating from Africa. So often if you're dealing with persons unknown and it's involving blackmail in relation to the dark web, then you will definitely need to be looking at certainly alternative service and service out of the jurisdiction. Those are very specialist areas, particularly service out of the jurisdiction, where you have to look at the practice direction 6B, and there are various gateways, but often where you have breaches of confidence or confidential information being leaked and damage in this jurisdiction, then you will satisfy those gateways. But it's an interesting case to have a look at that, and also the need to go for alternative service. So that was Watson. And then a couple of more cases just to touch on, perhaps of interest because of the facts. But those of you might remember the case involving the leaked report in relation to the Labour Party on the eve of Keir Starmer's election to replace Jeremy Corbyn. So certain individuals made an application for an anonymity there with the leaked report potentially identifying them, and they didn't want to be identified in that way, and those individuals wanted the use of ciphers to be deployed, and there was a broader application to withhold addresses. The defendant there was the Labour Party, and they were neutral on the application for an anonymity order. And yet again, it shows you the court had to scrutinise the application. And although the individuals did succeed, it was for very limited relief. I think the interesting point there is both individuals who applied for anonymity were essentially saying that the fact of the litigation was going to cause serious risk and harm to them. And it's interesting because their evidence dealt in some detail with the impact of the litigation and the potential further risks as a result of what the report dealt with, which was issues of anti-Semitism and the fact that extremists and extremist websites were potentially threatening to cause harm to them and their relatives. So the evidence itself did deal with their subjective fears, but the court found that that was all relevant information. But I think the interesting point there is, and particularly because they were claimants, so claimants obviously choose to issue a claim, although the claimants there may well have felt that they were staring down the barrel of Hobson's choice in issuing the claim. They had no option, they said, but to issue the claim to prevent their identities being revealed. But the judge found that even so, the fact of litigation in and of itself, and the fact that that obviously will carry some publicity, will not suffice for an anonymity order. In fact, the tipping point there was the fact that this report then was being used by extremists and extremist websites to incite essentially, potentially violence and risk to the person, that was the tipping point rather than the fact of litigation. So that's an interesting case perhaps to consider where individuals are fearing for their own safety. But that case goes through, again, the relevant guidance and the relevant rules. And there, interesting, the court determined that the concealment of the addresses of all the claimants was far more straightforward as opposed to their names, and that the concealment of addresses was less likely to interfere with open justice because it wouldn't impact on the public's understanding of the case. So again, perhaps it's useful to consider, are you acting for claimant or defendant? Where arguably if you're acting for the claimant, then you may well have more of an uphill struggle because you've chosen to issue the litigation, and then the nature of what you're asking for it addresses, it may well be, would appear to be a restriction the court is more likely to provide rather than blanket anonymity. And then finally, I think I've just got just a couple of minutes to deal with the last case, the most recent case on the handout, which is the BBG case. And that is an interesting case because it deals with an individual as opposed to a corporate entity. And what was in play there was cause of action was misuse of private information, so MOPI and harassment as the causes of action. There was a private individual who was openly gay, and he was active in his religious community, and he was being threatened and harassed and blackmailed by certain individuals in relation to private information, intimate and explicit material. And even so, the application had to be made and the burden had to be discharged in relation to those derogations. So there, the application was for anonymity and the hearing to be in private. The application was made without notice. So again, what the evidence had to address was the guidance, Rule 39.2, Sub-Rule 3, and Sub-Rule 4 in relation to an anonymity order as to whether it was necessary and strictly necessary in the sense set out in the rule. There was also the need to address the good reason for a without notice application. So the evidence has to set out the reason why. The good reason there was tipping off. Effectively, there was an ongoing investigation. So we can see overtones there from the Watson case, where there's an ongoing live investigation that can be a useful piece of evidence to deploy for both a good reason to go without notice and also for satisfying the need for the hearing to be in private. And there, the anonymity order was granted on the basis of Rule 39.24 and also under Section 11, which I mentioned of the Contempt of Court Act 1981, which is the ancillary provision. And that gives you the springboard into seeking potentially other restrictions. And there were some creative orders sought and granted. So it's one to note potentially in that respect, where there was an order made to restrict the disclosure of the fact of the order until the return date. It was an exceptional course, but the court was willing to do so. There also the order was directed against particular individuals rather than just persons unknown. But the wrongdoers there were capable of identification because they'd rang the victim and they'd emailed him. So the court had their contact details, if you like. But even so, those were put in a confidential schedule for fear of jigsaw identification. So it gives you some idea as to the sorts of remedies that the court might be willing to fashion depending on the facts. And indeed there, the judgment itself was postponed until the return date, again, because of the jigsaw identification issue. So hopefully that's given you a flavour of the types of cases that are coming out of the courts right now, and a useful starting point. And of course, if that piques your interest and you have a case that raises these sorts of derogations, then there's always Mark and myself that you can come and speak to, pick up the phone in the first instance. Often these cases are highly pressured in time as well and urgent. So it's good to know where to at least start and some key authorities to have a look at. Thank you for your time.
Thank you, Tina. I just want to bring up just 2 points. Very interesting question we had in the question box. Someone is asking about what about when it comes to enforcing a final order, for example, an application for a charging order where the judgment is anonymised. Well, a charge order would be relatively straightforward, but you'd have to apply to anonymise those proceedings on the basis of if you took the charging order in public, then you'd be relying upon the anonymised judgment, and that would risk jigsaw identification. What is more difficult is bankruptcy. Because there is an overriding public interest in knowing that a particular individual has been made bankrupt. Otherwise, you wouldn't be able to manage and administer their creditors if people couldn't know who the bankrupt was. So there's particular steps you have to take there. Also, committal for contempt of court of an injunction where you've had anonymised and private privacy orders made. Because, again, the overarching principle, which is very rarely derogated, is the name of the person being committed has to be publicised. And what you're finding in those cases, the court's almost doing 2 judgments. There's a judgment which has all the confidential information it's had referred to, which isn't for private, and then they have to prepare another one which omits all the confidential information, which is available on the court website. But again, it's I think what this stresses is you've got to keep it under review all the way through the proceedings. Is there anything happening which could be undermining the steps that you're taking? Second point, just to rise to what Tina said, that I do find in these cases that just bouncing the idea off somebody in a team is a very good idea, because it will inform your approach to the court. Why do we need privacy here? Why do we need anonymity? If you've had the discussion between your team, I think you find very much that you've done your work for the evidence. And the next issue, the one which we're coming across very often in practice, and it's linked to confidential information type of case, but also other cases, is you have a client who comes along and, say, for example, a junior employee has been tricked into disclosing confidential information or something like that, or giving away private details. And the company comes forward and says, 1, we don't want the junior employee to be embarrassed. But 2, more importantly, if this gets out in the public, our business could be really damaged because customers trust us. And if they know we've done this, and those that you're seeing that now, and the court's having a lot of sympathy for those applications because they don't want to drive proper litigants from the court, especially by wrongdoers who are relying upon people being too embarrassed probably to come through the court. And those are cases where the courts will have a lot of sympathy for private hearings and also anonymity. As I said at the beginning, the materials are available through Chambers. I think they'll be all ready by the end of the day. So please liaise, and thank you very much for your time, and have a very good day. And we look forward to seeing you again soon, hopefully in person. Thank you very much.
Thank you.